children or care leavers who are EU nationals but have yet to be registered on the government EU settlement scheme. Without this legal security, there is a risk that these children being made no recourse to public funds or perhaps even deported, even after they have lived most of their short lives in the UK. So the registration of children and care leavers on the EU SS settlement scheme is of crucial importance. The Children's Society is a national charity committed to improving the lives of children and young people. They work across the country with some of the most disadvantaged children and young people through their specialist services. Amongst the children and young people they support are children, young people and families who are subject to immigration control or whose access to services is restricted by immigration legislation. BASWs is the professional association of social work and social workers with over 22,000 members across the 4 nations of the UK. And we will be recording this session. It's now my privilege to introduce the speakers for this morning, or even this afternoon. We have Katie Hamilton and Vanessa, I hope I've got this right, Vanessa Mafufu of the Children's Society, who are going to be talking to us about the EU settlement scheme, who needs to apply, the process and the requirements. We'll be hearing from Maria Houlihan, who's social worker and service manager, Greater Manchester Immigration Aid Unit, who'll be talking about the settlement scheme for children in care and care leavers. And it's also a real pleasure to have here Sarika Kolai, who is the solicitor with Derby City Council, who'll be looking at this with local authority insights and suggestions. Final half hour of our session today will be devoted to questions and answers and discussion. So do put your questions in the chat box and my colleague Marieka will be moderating those and managing the process as we go in. We've still got people joining us, which is great, but I also think that we probably need to start because some of you are taking precious time out of work. So it's a real pleasure to hand it over to Katie and Vanessa. Over to you.
Thank you, Luke. Hi, everyone. I hope you're doing very well this afternoon. So my name is Vanessa. I am a migrant advice project worker for the Children's Society, and I'm with Katie here. So this afternoon, we are going to be talking a little bit about, actually, sorry, let me just,
Can you see this? Can you confirm that you can see the slides that we're sharing? Yeah. Okay. Excellent. Just give us 2 seconds.
Right. Yeah. There we go. Right. Okay. So today we're going to be talking about what EUSS is, who needs to apply, the application process and the requirements. And we're also going to cover how the status is granted and what happens after that. And in addition, we're also talking just a little bit about complicated applications, and that will be us for today.
Yeah, so like Vanessa said, we're just going to talk quite generally about the EU settlement scheme. We're aware that people may already have a little bit of background, but it's just to kind of give a bit of context to people that don't, and then the other speakers will go into more detail around looked after children. So firstly, what is the EU settlement scheme? So in brief, it's the UK's immigration system that was developed by the government in light of Brexit, so in light of the UK leaving the EU, to make sure that EU citizens living in the UK and their family members secured some kind of immigration status, some kind of formal immigration status, to be able to stay in the UK after Brexit and after the transition period. So EU law continued to apply in the UK until the end of last year, so until the 31st of December 2020. As of January this year, the UK has implemented a new immigration system. The application to the EU settlement scheme is free.
So the EU settlement scheme has been fully operational from March 2019. The end of the transition period was the 31st of December last year. So which means that those who arrive like in the UK from the 1st of 2021 will be expected to apply under a different category of the immigration rules. So the deadline for EEA citizens who have been residing in the UK before 31st of December 2020 is June 2021. However, there are exceptions at the Home Office discretion. So the Home Office has provided a list of reasonable grounds for applying after the deadline. For example, with those in abusive or controlling relationships who were like prevented from applying or having like the documents that they needed to apply in time. So that's just like an example, and the other one could be like homelessness as well. But forgetting to apply or not knowing about the EU settlement scheme is not a reasonable ground for applying, for not applying in time. So we advise everyone, if they can, to apply before the deadline.
So who needs to apply? So the biggest category of people that fall into will be all EEA nationals that, like Vanessa said, that were living in the UK before the 31st of December last year. So this is regardless of their time in the UK. So someone could have been here for 40 years in the UK. They will generally need to apply. Someone may have also only been residing in the UK for a day or two before the end of last year. They also need to apply. As long as someone can prove that they were resident in the UK, they are eligible to apply. So, like I said, the biggest category of people will be direct EEA citizens themselves. So that's EU citizens plus a couple of other countries in the EEA. It's also their family members. Their family members can be non-EU or non-EEA citizens also. For example, you might have a German national who's lived in the UK for a few years and their spouse may be non-EU. If they have been married and can prove that, then they can apply as well. So family members also includes children, spouse, and a few other categories. It's important to note that in terms of who needs to apply, it includes all children. So it's even those that are born in the UK. If a child does not have a British passport, the advice is to apply if their parents are EU nationals. So this is a common misconception in our work. Parents think that children have British birth certificates, they were born here, and therefore they don't need status. They do. The recommendation is always for children to apply, regardless of their age.
Okay, so the application process and the requirements. So all applications are done online, and we also use the ID document check app to scan the identity documents with the biometric chip. This is done to verify the applicant's identity. So the applicant will be asked to provide a mobile number, and this will be used to send them a 6-digit code, and they'll also need to verify their email before the application goes through. So the applicant needs to prove identity and nationality, also to prove the length of their residence in the UK, and also disclose any criminality if relevant.
In terms of what can be used as proof of identity, so for both EEA and their non-EEA family members, a passport can be used, a national passport. A national ID card can also be used, so this applies to EEA citizens, and for non-EU citizens, if they have a biometric residence permit that shows their relationship to the EU family member, they can also use this to apply. So those are the three main options for people applying online.
Okay, so when applying to the EU settlement scheme, the applicant will need to provide evidence to show whether they qualify for pre-settled or settled status. So pre-settled status is for applicants who've been in the UK for less than 5 years. So they need to have been in the UK before 31st of December 2020, and they only need to provide one document with their name on it and updated within the last 6 months before 31st of December 2020. So applicants who've been continuously residing in the UK for 5 years or more, by the time of their application, they'll be eligible for settled status, enabling them to stay in the UK indefinitely. So these applicants don't need to evidence the last 5 years. So it can be any 5-year period as long as the applicant hasn't been absent from the UK for more than 5 consecutive years. So according to the Home Office, so applicants can provide their national insurance number to confirm their UK residence. So the online form will automatically check the HMRC and the DWP for evidence of their residence in the UK. So if the checks indicate that the applicant has been continuously residing in the UK for a period of 5 years, they'll be granted settled status. However, if there are gaps in the automatic checks, then the applicant will need to provide more evidence. However, from our experience, in the majority of cases, this is not always the case. Therefore, we advise that applicants applying for settled status to provide evidence to prove their residence in the UK. And the examples is P60, council tax bills, tax credit letters, utility bills, bank statements, mortgage statements, tenancy agreements. There's like a full list of the residents available in the website below, but we found that annual documents are the best in terms of proving their residence in the UK.
So I'm just going to talk very briefly about the most common, less straightforward applications that we come across. So as I mentioned before, with regards to, for the majority of people, they will need to apply using valid ID, valid meaning in date, i.e. not expired. Of course, there will, so the first port of call, if a client does not have valid ID, is for them to try and obtain some, or to show the Home Office that they are taking the steps to try and obtain some. However, the Home Office do recognise that some people are, for kind of circumstances beyond their control or due to compelling practical or compassionate reasons, some people cannot obtain ID. This could be on health grounds, for example. It could be on financial grounds. This is at the Home Office's discretion. If there are cases where someone is not able to either obtain an ID for the first time or renew the ID that they have, so i.e. they have an expired ID, then the Home Office will grant a paper application form so the client does not have to apply online. This is becoming increasingly common for the clients that we work with the closer that we're getting to the deadline, because the Home Office, they recognise that if someone is now applying for a new passport, even if they have the means for that, the chances of them getting that new passport before the end of June is unlikely. So they will generally issue a paper application. However, when we do the paper applications, the Home Office will ask for a reason as to why the client cannot obtain a valid ID and apply online. So the client will generally need to prove in some way why they can't obtain that ID. So for example, if it's on health grounds, if they can provide a letter from their GP or medical records just to show this is the reason why, then the Home Office will generally accept that. But the most important thing to remember is that the Home Office will generally ask for proof as to why the client cannot obtain a valid ID. It could also be, for example, if a client has booked an appointment at the embassy to renew their ID, but they will not get that in time for the deadline, any contact with the embassy to show that the steps are being taken, this is also enough. So any kind of proof that says why the client is not applying conventionally, then yeah, that's enough.
Okay, so once a decision has been made by the Home Office, the applicants will receive an email to confirm what status they've been granted, and this is for online applications. So applicants granted pre-settled status and can apply for settled status once they've reached the 5-year threshold. So the 5-year threshold, it doesn't have to start from the date on which the applicant got granted the pre-settled status. So it can include all the time that they've lived in the UK. So to qualify for settled status, they must maintain a continuous UK residence for at least 6 months of each year. And please note that for pre-settled status, pre-settled status will be lost after a continuous absence of more than 2 years outside of the UK. So for settled status, so this is indefinite and the applicant doesn't need to apply again. So they should be able to spend up to 5 years outside of the UK without losing their status.
So once someone has received their status, in the majority of cases, they will receive an email confirmation to confirm that they have this status. This is generally the case for online applications. If someone applies using the paper route, often they will receive a letter to their house which confirms their status. However, it's important to note that the email or the letter that they are sent, which confirms their status, cannot be used as proof of status. All applicants, regardless of how they applied, They need to, the status is digital, and if they need to view or prove their status, this must be done online. So the website that we've listed on the slide, this is the website that can be used. So it's, in order to log into this website, the applicant will either need they will need the identity document that they used to apply, their date of birth, and access to either the mobile phone or the email address that was used to apply, and then they can log in and use and view and prove their status. There is generally also, then they will follow the instructions to generate a code if they need to prove their status to someone. It's worth noting if someone applied using no ID, so if someone applied using a paper application and they didn't have any valid ID, when they go to view and prove their status online, instead of entering their document number, because they don't have a document, they will enter their case reference number, which they'll be able to find on the confirmation email once their status is being granted. You just remove the zeros from the beginning of this. The second thing to note is that it's very important that clients, once they've applied for their status, keep their details that are linked to their status up to date. So this is particularly the case with mobile phone numbers and email addresses, because when a client needs to view and prove their status, they will be sent a code in order to log in. They will be sent this by email or phone. If both the client's phone and email address are out of date and they no longer have access to this can cause significant delays in them being able to prove their status. So this website that we've got listed at the bottom, this is what can be used to update contact details and also identity document details if the client needs to update them. So this is very, very important that clients do this to ensure that the process of proving their status is as smooth as possible. So if you're supporting clients in applying for status, if you can kind of reiterate to them, show them how to do this if they need to in the future, this is really important.
Okay, so if anyone needs support in doing the EU settlement scheme applications, they can contact a support organisation in their local area, and the website that we've listed on there, you can find different support organisations throughout the UK, so you can just contact the one that's near where you live.
Thank you. Yeah, thank you for listening. That's everything we've got at the moment, but of course, if you've got questions at the end, we're happy to try and answer.
Thank you.
Thank you very much for that, Vanessa and Katie. As they were saying, do put any questions you have in the chat box. And it's now a real pleasure to hand over to Maria, who's going to lead the next section.
Thank you. I'm just trying to turn this subtitles off because it'll distract us all. There we go. So I'm Maria. Thanks, Katie and Vanessa. That was really useful. And hopefully I'm just going to build on that and apply it more specifically to children in care and care leavers, and also kind of other children and family issues that will come in contact with social services. So I'm a social worker and I'm based at Greater Manchester Immigration Aid Unit. We cover the Northwest. We're mainly a team of solicitors and immigration caseworkers, and then there's myself and some support workers who are particularly focused on people more vulnerable because of their immigration status. So there's our contact details. So what I'm hoping to do in the next sort of 20 to 25 minutes is highlight the role of the local authorities in supporting children and families with these applications, to talk about some complicated and difficult cases. I'm going to touch briefly on British citizenship and how that's an available route for some children in care. And then at the end, there's quite a lot on where to go for more help and advice. So I'm going to talk quite fast because there's a lot to get through, but these slides, we can email them to you at the end, and there's lots of links in mine, so don't try and write them down or anything. We can email them at the end and then you can just click on them. One thing I really want to get across as part of the session is for social workers and local authorities to start looking at immigration and nationality and embed it into practice, and it's part and parcel of social work practice. We've got the EU settlement scheme, and that's forcing us to look at the issue for EU kids. But more widely, we should be looking at immigration issues for all children in care, and if we start with that as kind of standard practice, we'll pick up the kids that need to apply to this. So there's a worry that there's some children that are going to get missed because there's some tricky cases that they're not obvious that they need to apply for the EU settlement scheme. So if we look at everyone who's got immigration needs, we should pick up everybody. And also to highlight again that the deadline of the 30th of June you know, this issue won't go away then, because there'll be kids coming into care in July or a year down the line or 10 years down the line who should have applied to the EU settlement scheme. So if from now we start thinking, you know, we need to address immigration issues and always get immigration advice for children coming into services, then they'll get picked up, you know, and it'll just become normal practice, you know, for everybody. So, children in care in respect to the EU settlement scheme, this is kind of a bit on the numbers. So originally the Home Office estimated there would be 9,000 children in care and care leavers who need to apply to the EU settlement scheme. And this is kind of largely based on the fact that about 5% of the whole population is an EU national or family member. Now, then when they went out to the local authorities, and local authorities reported that there was 3,300 children in care and care leavers. So we're worried about the discrepancy there. Children's Society produced a report, you know, saying they're confident the local authorities have undercounted. And that's in part because it's difficult to identify all the kids. You know, it's asking social workers to be immigration advisors sometimes, you know, so that's why it's tricky, I think. And so we need social workers to have a real good look at caseloads, you know, and services to have a look to make sure no one's missed. So less than half of this number have applied so far, even though the scheme's been open for quite some time. And 840 of those have got settled status, so the most secure status. You know, so there's a lot of work to do. The Home Office is collecting this data again. These figures were from November, so they're collecting the figures again now, or they recently have done. So it'll be interesting to see, because I think there is a push now within local authorities to identify more children. There's a link there to the figures broken down by local authority, and that's quite interesting to see. You can have a look at your own local authority and see whether, you know, you think it's about 5% of your total looked after and care leaver figure, or if it's way off, and such like, and how you compare to other local authorities of a similar kind of makeup. So there are mandatory responsibilities for local authorities to identify and support children who need to apply to this. And there could be legal consequences for not resolving immigration issues, and there have been in the past, and you know, local authorities have been fined for not supporting children, and there are big consequences for the children themselves. You know, in the future they could face deportation, you know, if they haven't got their immigration issues resolved. So sorry, that's the scaremongering bit. So what to do? So there's guidance, there's Home Office guidance that's specific for children and care leavers. So that's really key reading if you have got any children on your case who need to apply. So key points in the guidance are the responsibility depending on the status of the child under the Children's Act, and I'll go into that a bit more in detail on the next page. It's one of the things is to identify and give support to all children family coming in contact with services. So that's early help families as well, and Section 17 children. And the important thing there is if those families don't apply, come 1st of July, they might find that their benefits stop, their housing stop, they can't work. You know, all those things and all those protection measures will fall away. And it will be social services that they'll come to, you know, to help pick up the pieces while they, you know, sort their immigration status out. You know, in practice, that it might not be as extreme as that, but that is the worst case scenario. So the more we can do now to support those families to make sure they have got the status and can still access benefits and such like, the less likely it is to impact on local authority support. So this guidance also gives a list of key application information that must be recorded in someone's notes. So as Katie and Vanessa said, it's really important to have things like emails and phone numbers, especially if it's the social worker applying and using their email and phone number. You know, social workers change quite a lot. You'll need to update it. The next social worker will need to know which, you know, what information was used, so they can access the record. In particular, if it's supporting a child who's got pre-settled status to convert it to settled status. And it's really important that that isn't missed for those children who haven't been in the UK for 5 years yet and haven't got settled status. So that's got to be in the plans and got to be in pathway plans. So here's the sort of the responsibilities broken down in a bit more detail. So for everyone, no matter what their status under the Children Act is, it's to identify people who might be eligible for the EU settlement scheme. And then if they're children in care with a full parental responsibility to the local authority, it's ensuring that the application is made. So the local authority is responsible for making the application and can actually make the application. So normally it's level 1 immigration work, and social workers won't be able to do that type of work. But the Home Office has said in these cases, for these children, social workers can make the application. The children can make them themselves if they're, you know, kind of an age that a maturity that they're able to do that, you know, and perhaps you just provide support of how to do that themselves. And again, it's making sure it's very clearly in their plans that what's been done, that they've got settled status, or if they haven't got settled status, that when it can be converted to settled status, and that's at the point they've done 5 years in the UK. So accommodated children where someone else has PR, we need to make sure that the person with PR is aware of the need to apply, you know, and the risk and the consequences for not doing so. So it's about monitoring the application process, keeping on track of it, making sure it is done, signposting for assistance and providing any practical supports that might be helping with renewing passports and things like that. Where there's no one with PR, then it's acting in the best interest of the child, and it will always be in the best interest of the child to get this done. So it'd be referring to an organisation to help them go through the process and get this done, or the child could do it themselves, you know, if they're capable of doing it. Section 17 children early help child protection cases, it's promoting the scheme, making sure all those families that we're working with are aware of it and they know where to get support. And then care leavers, again, it's you can't do the application for them, but you can help them to do it, or refer them to an organisation that can help them. Again, those applications need to be monitored. And really key for care leavers is that they know, if they haven't got settled status, that they know when they need to convert it to settled status. They might not have the benefit of a personal advisor or a social worker to help them do it in the future, or reminding them they need to be done. So it needs to be really clear on their sort of pathway plans. You know, in 2 years you'll have to apply for this, otherwise you'll lose your benefits and stuff. Okay, so who should apply? So we've heard like who's eligible. And actually, we could spend probably a week's training session on who is eligible for the EU settlement scheme, because it's EU, EEA nationals, their family members. It can be extended family members if there's a dependent relationship. So, you know, an uncle's looking after his nephew and the rest of the family aren't there. You know, or it can be what's called derivative rights cases. Or estranged family members. So there is a family member who's passed away. You know, there's different kind of links to EU nationals that make it more complicated. And again, what I'm going to say is make sure that anyone that you're concerned about, immigration wise, nationality wise, you're getting support for. And then an immigration advisor will pick up those tricky ones, hopefully. So what to do, what should you do in practice? You know, have a think about your caseload. And I would start with thinking, who's definitely British? How do I know they're British? You know, don't make assumptions. If someone's born here, it doesn't necessarily mean they're British. And quite often they're not, you know, so the best thing, if it's kids in care, you should always be trying to get someone their passports, you know, and that's ID for them. It's a really important document. And also it helps you know that they are British or whatever nationality they are, you know, and any problems will arise, you know, during that process. So start with those who are British. Are you sure you know they're British? You know, and then who's not British? So what nationality are they? Do we know what their immigration status is? Start asking questions and doing some digging. You know, what are their family members' status? When did they come to the UK? On what route? You know, genograms and those sort of things are really useful, and it's the type of things that when you do refer to an immigration advisor, they're going to ask these questions, you know, and want to know a bit more about the family, how, you know, when they came to the UK and on what kind of status did they came to the UK. So these are children that you need to get advice for. So it's thinking more broadly than just I've got to work out who's eligible for the EU settlement scheme. Okay, and then once you've identified some children that need to apply, where do you start? So start by reading that guidance, that Home Office guidance. So it's useful to tell you what information you need to save and what your responsibilities are. And then again, like Katie and Vanessa pointed out, before you start, you need the following things. So proof of identity and nationality, and that will be a valid passport or national ID card. Proof of residence in the UK. So ideally, if they've been here for more than 5 years, you'd have 5 years residence, or if they haven't, then you just need something from before 1st of January 21. And then if they're over 18, you have to declare any criminal offences. Under 18s don't need to declare offences. So if anyone's done this process, I'm sure you'll know that the hard work often is trying to obtain ID documents. So it might be that a child's been abandoned in the UK, or the parents aren't engaging, or it would put the child at risk to try and get the parents engaging to try and sort out a new passport. So there's lots of problems that people are facing with trying to get passports. I know people have been trying to do it for months, you know, trying to renew passports or get a first passport for a child. The starting point would be approaching the embassy of that child's nationality, and embassies, they are very well used to now social workers emailing and contact them and saying, we've got this child in care, we've got a full care order, or this is the situation, you know, we need to apply to the EU settlement scheme, you know, how can you help us, basically. Some embassies are being really helpful. Like we've had Manchester services have had an email or letters from the French embassy and the Polish embassy to say, look, we're here to help, you know, we want to help you. If you've got a child and you're struggling to prove their nationality, contact us and we'll help you. And you know, they can do certificates of nationality and things like that. So they'll be used to that. So do get in touch with them at the earliest opportunity. So I've just let these on. So there's two kind of routes that, you know, and Katie and Vanessa did touch on this already, so I won't go into detail. But so there's the online route, and that's where you have the evidence. You know, that's kind of the supposedly simple process if English is your first language and you're tech savvy enough to use the apps and the online process. So if you've got the documents ready and you've got a valid passport, then you do the online route. On this slide at the bottom, there's a video, and it's produced just by a solicitor's firm, but it's a really helpful video that talks you through it step by step. So if you are doing one, then I suggest just have a watch of that video, and it'll put everything into place for you, you know, before you have to do one. Complex cases, this is the paper applications that Katie and Vanessa mentioned. So these are where you haven't got a valid passport or biometric ID card. All these more complicated relationships to EU, EEA nationals, so estranged family members or derivative rights applications. For social workers requesting these applications, I think there's less kind of difficulty than if it's a member of the public. You know, so you ring this number at the bottom, the one ending 0566, and explain that it's a child in care, a looked after child, what the difficulties are. They'll ask the details and they'll send you the form with their information kind of pre-populated into it, and you fill in that form. I've not known anyone to have a problem with getting a form for a child who's under services. So if this is now looking at sort of complicated issues, so the ID issue is the biggest problem. So where you haven't got valid ID for a child, the specific guidance for the Home Office, and it's in there, it says that you can use alternative ID evidence if it's not in the best interest of the child for the local authority to obtain the identity evidence, or the significant practical difficulties. And there's a list here of the types of documents that you can provide, but this isn't a full list. And I've just been saying to social workers, get anything that you've got on file, you know, that shows any sort of official letters from other countries or from this country that's got the nationality on it. you know, why do you think they are of that nationality? We've had some situations where people really are really stuck, you know, abandoned children, that they've got nothing, you know, and it's, you know, and often by talking to the embassy, something comes out. Often these things come out during the care proceedings, because there might have had to have been a consideration about where the child should be, you know, and involving the authorities of that country. So it could be that though there's documents in the care proceedings, and obviously you need to just be careful about disclosing those, so you might need to go to the family court to get permission, but often there's something, you know, on file. And then we need to show residency in the UK. So the kind of the online straightforward route is through a national insurance number, checking against HMRC and DWP, but obviously that's not going to be useful for our children and even our care leavers, because they won't have worked long enough. So nearly always it's a letter from the local authority is the easiest. So from yourselves, you can say, we've known this child under our services for however long. We're aware that they've been in the country since whatever date. But you'd need to be able to evidence that. So if you only know them for the last 3 years, then you might then think, OK, we need to go to school to get attendance records, or GP or other services that have been involved, health visiting team, that sort of thing, just to show how long that child's been in the UK. So again, if they've been in the UK for more than 5 years, they get settled status. And if it's less than that, it's pre-settled status. So if you have a child who's been in the UK for more than 5 years, but you just can't prove it, speak to an advisor, because we really need to be getting them settled status, because it's a much more secure immigration status, and it's much there's a lot less faff going on in the future. You don't have to do any conversion to settled status. You know, they can leave the UK for more amounts of time than if on pre-settled status. One thing to highlight is that if the parents have got settled status, then a child can link their application to the parents' application and get settled status on the back of their parents. So, for example, you know, parents have lived here for 10 years. They've got settled status. A child is 2 years old. You know, without the parents, they would only get pre-settled status. But if you can put in the parents' details of their application, they will just automatically get settled status. Now, this is fine if you've got parents engaging and they'll give you the reference. You need their 16-digit reference number from their application. So that might be the tricky bit, and it might just not be possible. But where it is, you should try and link them up. OK. Criminality issues. So this is perhaps the second biggest issue that we're facing. So children don't need to disclose offences when they're applying, but anyone over 18 does. If you're concerned about a child's criminal record, speak to an advisor first. It should be only persistent offences, you know, kind of long custodial offences that get considered by immigration enforcement. But you know, it might be worth talking to an advisor first. You know, how might these criminal offences affect someone's application? They'll check against UK databases and overseas databases, and it's really important that, you know, if they're over 18, they do disclose everything. If there's ongoing investigations, this will delay the outcome, and sometimes those delays are unnecessary if the crime's, you know, quite insignificant, a petty crime. You know, so we've got people who are delayed for months and months and months because they're waiting on a court case for something, you know, shoplifting or something, or, you know, that's not going to get them deported, you know, and those can be challenged, you know, because the delay could cause them to not be able to access benefits and things like that. So do speak to an advisor if that's happening to one of your cases as well. If there are children on your caseload who you're worried about future offending, something to bear in mind is that offences currently are looked at under EU law and regulations, and they've got to be considered under EU regulations, and they're more lenient than UK law. So any offences now committed now, there's a different approach to them, and there's talk of like the policy at the moment is deportation for sentences over 12 months. and there's talk of changing that to 6 months. So that could be really serious for some people, you know, who are likely to offend or possibly likely to offend in the future. So the outcomes, as we said, so it's either settled or pre-settled, depending on the length of residence. The application could be put on hold because of criminal investigations, or it could be refused. Now, there's an appeal process if someone applied after the 31st of January 20. So if you're worried about anyone getting refused and they applied before that date, my advice would be just reapply, so you've got that right of appeal. And as we said, there's no physical document, it's all online. And it can be accessed online. So just to touch briefly on British citizenship, so it's estimated that there's about 200,000 undocumented kids in the UK, and as many as half of them are British and just can't prove it. So there's real risk to these children, you know, that could be socially excluded. There's the risk of removal to a country they've never set foot in, you know, if there's future criminality. So it's really important that local authorities look to get the most secure immigration status for children, especially who you know, whose future is in the UK and they are, you know, they're staying in the UK, you know. So there's some examples here of which children can apply for British citizenship. So it's children who are born in the UK to a British or settled parent. That one's maybe the obvious one, but then there's children who are born in the UK to parents who subsequently become settled or British. Any child who was born in the UK and has lived here 10 years, and that's probably quite a lot of children on caseloads out there. And then arguably there's this discretionary route, any child whose future is in the UK, you know, and that might affect a lot of kids, you know, and it might be really advantageous to them to look at this and work out, you know, have a best interest decision, speak to an immigration advisor, you know, should we be doing this for the child? Dual citizenship is almost certainly the most advantageous for children and young people, especially those who've got an EU nationality, because you know, it gives them the possibility then to go and work and study, travel in Europe a lot more easily now than if you've only got a British passport. So definitely, you know, don't be trying to lose the EU nationality. You know, if ever someone's nationality changes completely, it has to be a court decision as well. So, but dual nationality is often possible. So definitely get immigration advice to weigh up the options. But, you know, we were saying best practice would be to push for British citizenship for children in care. OK, and then finally, sort of what can social workers do now? So, you know, go back and have a look at your caseloads and think, you know, have we looked at immigration issues for all these children? Is there anything else that we should be doing? Do we know their nationality for sure? You know, there's probably, you know, we've all heard of the Windrush scandal, you know, and there'll be kids, you know, generations on from those people that didn't know that their grandparents weren't British or hadn't regularised, you know, and if someone's never left the country, they might have never applied for a passport, you know, you just won't know until, and we've seen it often at our place, you know, people apply for work and at that point, you know, everything unravels and they can't access benefits or work or anything like that. So sorting it out while they're children is much easier than when someone's an adult. So OK, so and build it into support, build it into practice, you know, offer support with immigration just as you would with housing and benefit applications. Find out what services are out there and how to link people to them. Managers and supervisors talk about immigration issues in supervision, and then ideally at, you know, kind of a systems level, how do we pick up immigration issues, you know, record nationality on your systems and such like. OK, and then just at the end here, there's some links to some useful information. So there's a child-friendly guide to the EU settlement scheme from the Liverpool Law School, so that's really useful. There's some guides in other languages produced by Europea. And there is someone on the Home Office website as well. Settled have just produced a really good, useful leaflet about children and families and getting the EU settlement. So I think on the back of the fact that the Home Office are aware that not many children are applying, so they pushed out this leaflet to raise it as an issue. So encourage parents to apply for, not to forget to apply for their children. There's this Home Office We Are Digital scheme. That's sort of helps people through the technicalities of how to apply, you know, how to download an app, how to fill in a form. So that might be useful for some people who aren't very tech savvy. It's in English only, I'm afraid. And here's some more useful information. There's Unlock, that's advice to people with criminal records. Quorum's a really useful organisation for children's rights. Children's Society, of course, two brilliant reports about this whole process and advice for local authorities. And then there's a couple of webinars in there as well from Article 39. And then again, where to go for help. So this is the same link that Katie and Vanessa put on. So it's a link to the grant-funded organisations nationally and locally who can help with these applications. Of course, if you're in the Northwest, I'd be happy to, for you to email me and I can ask our solicitors if it's a more complicated case. And then there's some other services. Kind at the bottom, they specifically help people with British citizenship. So you can approach them if you've got a child who needs to apply. And that is the end of my bit. I'll just try and work out how to stop sharing. There we go.
Maria, that was great. Thank you. And congratulations to all three speakers we've had so far, because we're actually on time. How often does that happen? So it's a real pleasure now to introduce Sarika. And she's a solicitor with Derby City Council, and she's currently overseeing the council's work to submit applications for looked after children and care leavers. Sarika, over to you.
Thank you, Luke, and good afternoon, everyone. As Luke mentioned, I'm a solicitor in the childcare team at Derby City Council. I advise on child protection matters and immigration matters. Now I've been quite involved in advising children's social care in respect of their obligations under the EU settlement scheme, and I'm hoping to cover some of the issues that we've encountered and resolved, so that you have some insight into what this looks like on the ground, what your frontline staff need to know, what they need to do. So one of the biggest things, as has already been mentioned, is the identification process. Now, in order for the local authority to fulfil their statutory duty, you're required to identify all children and care leavers who need to make an application. What does that look like? Now, there are lists of children already in the guidance. So those who are looked after, they're on care orders, interim care orders, Section 20, they're accommodated, and children working in social care. For me, I've split that into 4 lists, slightly different. So my first list is children who are on care orders, then care leavers. Now these 2 lists remain quite static with a few exceptions. And those children will be with the local authority until they're 18, generally, and that list doesn't change. Now, the third list for me is children on interim care orders. They're in the midst of care proceedings. They will not remain on interim care orders. They may become subject to care orders. They may become subject to supervision orders. Our statutory duty changes. So you need to be mindful of what that looks like with the child's legal status. Now, the 4th list is children who are working with social care. They're perhaps on plans, on child in need plans, on child protection plans. We don't have PR for these children, but we need to support, advise and assist so that the children and their family members are in a position to apply for, to make applications to the EU settlement scheme. Now, we already have processes in place, obviously, for safeguarding, for child protection. A child's immigration status can be identified and tracked as part of that process. Now, if your local authority is recording nationality as part of this process, you're halfway there. If you're not, then you need to. recording nationality needs to be mandatory. And not only will it allow you to recognise or identify which children need EU settlement scheme applications, it will allow you to identify children who need immigration advice generally. You can pull out children of a certain nationality when you need to review, and it's to ensure that children don't slip through that net, because it is very easy. Now, if I just quickly go back to that first list of children on care orders, some of these children have been on care orders for years. We've never had to look at a EU national immigration status previously, prior to Brexit, prior to the EU settlement scheme. And the only way that you're going to identify these children is a big task. You have to go through your list. You have to have your children in care teams, your permanency teams. They have to pull out these children. They have to go through the lists to be able to identify them. If you are setting up a new process where you are starting at the beginning of a referral, that's not going to help you identify children who are already in the care system. So the two things need to be done at the same time, given that the deadline's approaching. Now, I'm just going to cover some of the things that that you should consider implementing in your processes. The single assessment, relevant for most children, for all children on plans who are going into the PLO process. Record the information at that stage. When you're going into your CP conferences or review conferences, review that information. When you go into panel, when you're making the decisions on whether or not families going into proceedings, we already at Derby City, we record that information at that stage, so that if it has been missed previously, we'll catch it at that point. Speak to your independent reviewing officers so that they can review whether a child's immigration status has been resolved or has been dealt with within their processes. Now, when I get asked for advice on what do we need to look at, what do we need to ask families in order to establish who needs assistance, I have 5 questions, and the answers to those 5 questions will give me insight into whether the application's been made, whether it needs to be made, British nationality consideration, and whether this family perhaps needs more advice. So the first question, and the most obvious, is nationality. The second, date of entry into the UK. There's 2 reasons for this, and it will give you 2 lots of information. Firstly, how long has that child been resident in the UK? Are we applying for pre-settled status, or are they applying for pre-settled status or settled status? The date of entry will also give you an indication of whether that child is eligible for the EU settlement scheme, or if they arrived in the UK after the 1st of January, are they subject to the new immigration rules? And it's important to differentiate between the two. Now, the third question is place of birth, and the 4th, parents' immigration status. Now, these 2 questions allow me to consider whether that child is already British. British nationality is obtained by virtue of your birth and your parents' nationality, and that information will either rule them out of British nationality so that we can continue with our EU settlement scheme application, or it will indicate that we need to consider it. We might need to ask more questions. You might want to consider taking legal advice at this point to establish whether the child is already British. And I'll give you a very quick example. If you've had a family who's been resident in the UK for years, they've been exercising their treaty rights, they've been working. When they'd completed 5 years, they obtained permanent residency. If a child is born after that, that child is automatically British. And so by knowing what parents' immigration status is, or how long they've been in the country, where that child is born, it will give you some indication for further consideration at the very least. The last question for me, what ID documents do they have? All immediate family members, parents, siblings, subject child, or if they're all subject children, because there's your evidence of nationality. if they have those documents, whatever those documents are, expired passports, birth certificates, valid passports, take copies at a very early stage so that you know what you're dealing with. And I've already mentioned at this point, if you're gathering this information at an early stage, the local authority cannot make applications on behalf of a child unless they've got parental responsibility. So you may find that you need to signpost to an external organisation. Now, if I can just now talk about when we do have parental responsibility. Children on care orders, on placement orders, on interim care orders, we have PR. Children on interim care orders, we are in the middle of care proceedings. There is a lot of information that we can gather at this stage. There you might find yourself in a situation where there has been no work done previously because proceedings have been issued on an urgent or an emergency basis. So we don't have that background information where we're looking at immigration status. We ask parents in Derby, in the Derby Family Court, we ask parents to address their immigration status in their response documents. We ask them to indicate what kind of ID documents they have. There is already a requirement at this stage to engage with foreign embassies for various reasons. It may just be that they want to intervene. It may be that they're trying to, that they want proceedings to be transferred back to their country of origin, or locating family members, completing viability assessments. Whatever the case is, they're already engaged. Ask them what their requirements are. The court are in a position to deal with whatever is required. Some foreign embassies, they require all parents to consent to applications for passports. We might find that parents are not consenting, they're not engaging. The court can direct that parental consent is dispensed of, which means that the local authority are now in a position to make that application if necessary. Whilst I think that that's always worth doing, you may not have the time to get it done from now and the 30th of June. So you've got to look at other forms of evidence, which has already been touched upon. Now, when you're looking at care proceedings, there is obviously, as I've mentioned, a lot of involvement with foreign embassies, and the evidence is there. You do need permission from the court. Proceedings that are in court right now, you can obtain that permission now. It's a direction. You can speak to your legal teams and they can put it in. You can go back to court retrospectively for children whose care proceedings have ended. But my last conference with the Home Office, they have indicated that although all of this evidence is acceptable, it's acceptable proof of nationality, they will also accept a legal position statement which talks about what we have on care proceedings files. Because to go back to court and to apply for an order where care proceedings are not, which have ended, will take time. So if we are able to look through our files, identify what is there, they will accept that as evidence. And that actually is quite far removed from what they state in their guidance, but they have confirmed that it's acceptable. We just have to mention what there is on the file, and as Maria mentioned, any documents, be very mindful and respectful of the court process, because you need permission to disclose to a third party, and the Home Office is a third party. Now, if I can go back to my lists, Excel spreadsheets, trackers, whatever you want to call them, children on plans, children on interim care orders, they're fluid. You've got to have somebody monitoring that, whether it's a team, a person, your managers, whatever. Somebody needs to make sure that children are put in the correct legal status so that you know exactly what your legal obligations are, and where your statutory duty is triggered, and where you don't have it. And that's important, because if, for example, you have a child who is on an interim care order and ends on a supervision order, you cannot make that application at that point, because you are not registered with the Office of the Immigration Service Commissioner, you don't have the authority to make that application. So you've got to signpost again. And then tracking applications. If you're applying for pre-settled status, you've got to make sure that the applications for settled status are completed. My final point to make, just a bit mindful of the time, is that you can only have an efficient tracking system or an efficient identification process if there's consistency. And the EU settlement scheme involves all teams, your first response teams, your early help teams, child protection teams, children in care teams. You've got to be able to track them efficiently. Just lost what I was going to say, sorry. Right, you've got to make sure that you can track them, that you can, everybody has a consistent approach on how to record the information. The Home Office guidance does state that one of the requirements is that we record information accurately. We make sure that we have identified children eligible, pre-settled status and settled status before we can actually end that process for the EU settlement scheme. Thank you. I'm open to any questions.